All right, personal injury. I think this is very underutilized. I think personal injury attorneys don't look to the special ed system nearly as much as they could. And I'm going to break away from the outline for just a second, because this is one thing that is a money issue. That's something to think about. Let's say you have a personal injury case, a pretty severely injured child who is able to go to school but needs nursing service in the school. Maybe has to be catheterized, maybe has a feeding tube, and he's in school. Maybe he's got problems with airways. I've seen quite a few, or they become a paraplegic and need a nurse in school with them. All the time, what happens in those situations is the parent goes to the school district, says, look, Jimmy can go to school, but he's going to need a nurse. The school district says, oh, okay, apply to medical assistance. Remember, we talked about medical assistance. It has to provide any medically necessary service. And your private insurance, talk to them. So the family exhausts the private insurance that might pay for the first couple months or something. Then medical assistance kicks in, starts paying for it, and you settle the case. Well, you settle the case, for, let's just say, $800,000. The healthcare people show up with a $100,000 lien for the nursing service in the school. Medical assistance shows up with a $200,000 lien for the nursing care service in the school. And here you are, and almost always what I see is the personal injury attorney negotiates those liens as best they can, and then distributes the money consistent with the representation agreement. Think about that. The school district has an obligation to provide the child with a free, appropriate public education. It's an absolute. One of those things, in fact, it's in the second outline that I gave you, the outline, Special Education, a Practical Overview for Families. As you look through it, somewhere in here, it talks about the various services that kids can get. One of those services are school health services. Page 8, it sets out the related services, and it includes school health services, meaning nursing service. So the school district has an obligation to provide those nursing services, and the right to special ed is at what they call FAPE, a free, appropriate public education. They can't make you pay for those nursing services. If it's required in order to access the special ed program, the district has to provide it. So we've got a situation in the hypothetical I gave you where you may have $300,000 in liens and you're looking to satisfy them. Maybe you can negotiate them down by $200,000, but frankly, you as the personal injury attorney may have given away $200,000 in that situation because the school district had an obligation to pay for it. Medical assistance wants to get paid back. The health insurance company wants to get paid back. And whereas if at the outset you said, hey, look, to the district, you've got to provide that because otherwise they're going to take that money out of my client's pocket. And they do, and I've seen it. And frankly, we've had cases where we've gone back to the school district and the school district has reimbursed the family in over 6 figures because they never told the family, by the way, this is something we have to provide, and they actually pointed the family to ways to get it in ways that it was going to cost the family and the child lots of money. And ironically, the Department of Public Welfare that runs medical assistance, they actually, under the law, have a concurrent responsibility with the educational agencies to provide a free, appropriate public education. The case name is Cordero, C-O-R-D-E-R-O. And it was decided in 1993 by Judge Rambo of the Middle District, who said that local school districts in the Department of Ed are not the only agencies in Pennsylvania that are responsible for helping to provide a free, appropriate public education. And so my position with DPW when I've assisted PI attorneys is that you can't get a lien on school health services because you're under a responsibility to provide FAPE with the district. The DPW has historically, in these cases, taken a relatively hard line, and because they hold the medical assistance cards, they have some leverage there in terms of trying to negotiate away that lien for providing the school health services. But the moral of the story is that the earlier you can get in and deal with the school district, and maybe deal with DPW. It may be something where the school district and DPW can work collaboratively to say, look, we're not going to put a lien on it. It's fine. Use medical assistance, access it, but there won't be a lien related to what's going on here. And that's a significant money issue for your clients in personal injury cases, and it is not that uncommon. So I think it's important to at least have that in the back of your mind. How else can a child's right to special ed be important when you're dealing with personal injury cases? Well, first of all, if the child was special ed before the injury, the special ed records are going to be very useful in terms of setting baselines for where the child was before the injury. The special ed teachers, and sometimes the regular ed teachers, are going to be very helpful in terms of identifying the level of skill and disability the child had before the injury and then where the child was after the injury. We have a case right now where a child with special needs was beaten up pretty badly in a placement and suffered traumatic brain injury. Well, in terms of working the case, it's very helpful to have the special ed records that preceded the injury because we can then compare the fact the child lost IQ between before the injury and after the injury. The child had expressive language issues before the injury that were exacerbated after the injury. So having access to those records can be extremely useful. And even if the child wasn't eligible beforehand, depending upon the nature of the case, depending upon how you want to work it, if you ask for an evaluation, for all intents and purposes, unless there's no basis for it, the district has to conduct an evaluation of the child to determine the child's educational functioning. So it is a useful way of getting a reasonably comprehensive evaluation fairly quickly. The school district has 60 school days to perform the evaluation. And if you ask for specific types of evaluations, of expressive language, of behavior, of emotional, of their fine motor skills, gross motor skills, districts will almost always at least perform basic testing in those areas. So it's a very good way of quickly, expeditiously, and totally inexpensively obtaining evaluations fairly quickly from licensed professionals. If the child is identified and has a need for therapeutic intervention, occupational therapy, physical therapy, speech-language therapy, and it's necessary for the child to have access to those services in order to make meaningful educational progress, then the district has to provide those services. So there's, I think, a significant benefit to looking to the district to do those. And again, those therapists can become your witnesses. As I said in the outline, it develops witnesses who can say what the child's functioning is like and how it has affected their day-to-day work, not only at home, but then you've got people in the school who can help you with that. One of the kind of little-known areas of special education is the related service of family training. And most school districts don't advertise that one of the related services under IDEA is family training. But lots of times parents have difficulty managing the child's behavior at home or in the community, and the family training can be hugely useful. In other words, people from the district need to go with the family and train the family in terms of managing behavior, in terms of sometimes extending what kind of therapy is going on at school and doing it at home, how to address homework issues. All that is part of IDEA, and family training is a very significant aspect that's underutilized.